Namaste everyone, and welcome back to today's explainer. I know you all are grinding hard on your Indian Contract Act preparations, so we're going to dive straight in. Today, we are tackling Chapter 2, Unit 3, Essential Elements of a Valid Contract. Let me tell you, this is absolutely one of the most crucial units for your exams. So, sit up straight, grab those notebooks, and let's conquer this topic together. Okay, let's kick things off with an absolute classic exam question. Tell me, क्या हर agreement एक valid contract होता है? Is every single agreement out there a legally binding contract? The answer is a huge resounding no. For an agreement to actually transform into an enforceable contract, it needs a very specific set of essential elements. Without those, honestly, your agreement is just a meaningless piece of paper. You can kind of think of a contract like a massive, sturdy building. For this building to stand tall, it has to be supported by 4 solid, non-negotiable pillars. If even one of those pillars is weak or missing entirely, the whole thing just collapses. Today, we are going to build this structure together, Dhyan se suna, because this is super important. All right, here is our blueprint for today. Pillar 1, capacity to contract under Section 11. Pillar 2, meaning of free consent. Pillar 3, lawful object and consideration. And finally, Pillar 4, expressly void agreements. Let's get moving. Starting strong with pillar number 1, capacity to contract, governed by Section 11. Now you really need to anchor Section 11 deeply into your minds. You see, not everyone can just walk into a room and make a legally binding contract. The law gives us 3 absolute rules here. To be competent, a person must first have attained the age of majority, which means 18 years and above. Second, they must be of sound mind. And third, they must not be disqualified from contracting by any specific law. Concept clear, hey? Okay, let's unpack that second point a little bit more. So what does it actually mean to have a sound mind? It basically means you're in your senses enough to understand the implications of the contract right at the exact moment you're making it. On the flip side, someone of unsound mind, say a lunatic or even a heavily intoxicated or drunken person, cannot make a valid contract. Think about it. If someone is completely drunk, they have no idea what they are signing, right? So the law steps in and says, nope, no valid contract here. Moving right along to pillar number 2, meaning of free consent, covered under sections 13 and 14. अरे भाई, contract ऐसे थोड़ी बन जाएगा just because 2 capable people are talking to each other. Section 13 clearly tells us that 2 or more persons are said to consent when they agree upon the same thing in the exact same sense. We call this consensus ad idem, which translates to a meeting of the minds. Let me give you a pro tip. ICI examiners absolutely love seeing this Latin phrase in your answers, so definitely memorize it. Consensus ad idem. But hold on, consent is one thing. Is it free consent? Well, Section 14 introduces us to the villains. It tells us that consent is not free if it's caused by any of these 5 things. Listen carefully and mentally file away these section numbers. Number 1, coercion under Section 15. Number 2, undue influence under Section 16. 3, fraud, Section 17. 4, misrepresentation, Section 18. And number 5, mistake under Sections 20, 21, and 22. If any of those first 4 villains are in the picture, the contract instantly becomes voidable at the option of the aggrieved party. They can just walk away. Let's look at pillar number 3 now, lawful object and consideration, governed by Section 23. Great. So we have capable parties, and we have their completely free consent. Now what? Section 23 gives us a very strict checklist of 6 conditions where the law firmly says, no way. The consideration or object is fully unlawful if 1. It is directly forbidden by law. 2. If it defeats the provisions of any law. 3. If it's fraudulent. 4. If it involves causing injury to another person or their property. 5. If it's deemed immoral. And 6. If it is opposed to public policy. Let's ground this theory with a couple of highly relatable textbook examples. Imagine a father arranging the marriage of his 17-year-old son and taking a dowry. First off, the boy is a minor, right? Plus, dowry is strictly prohibited by Indian law. So the consideration and object there are totally unlawful. Or take another classic example, paying a massive bribe to a public servant to secure a government job. That completely defeats the law and is opposed to public policy. Totally void. And that brings us to our final pillar, number 4, expressly void agreements. Now, sometimes, even if you think the first 3 pillars are perfectly fine, the law has simply declared certain types of agreements dead on arrival. Let's do a quick revision of this table. You really have to map the exact section numbers to the type of void agreement. Section 26, agreements in restraint of marriage are void. You simply can't legally stop an adult from marrying. Section 27, agreements in restraint of trade are void. You can't just stop someone from doing a lawful business. Section 28 handles restraint of legal proceedings. And Section 30, that covers wagering agreements, basically betting. All of these are expressly void. But wait, before we wrap this up, I need to highlight a really crucial exception for Section 27, restraint of trade. Examiners love setting a trap here, so pay attention. If a person sells the goodwill of a business, they actually can legally agree with the buyer to not carry on a similar business within specified reasonable local limits. In this one specific case, the restraint of trade is actually perfectly valid, so don't let them trick you on the exam. All right, let's finish up with a quick pop quiz straight from your practice modules to see if you've been paying attention. An agreement, the object of which is to procure a public post, like that bribe for a government job we talked about earlier, is it valid, void, or voidable? Think back to Section 23. I'm not going to give you the answer here, drop it in the comments below. And hey, here's a random thought to leave you with. Next time you blindly click I agree on a massive software update, ask yourself, did you actually have consensus at item? Keep studying hard, revise these 4 pillars, and I will see you in our next explainer.